Hello, my name is Vasily Tarasenko, I'm a Russian attorney. And the first friendly reminder, we have a Telegram channel, find the link in the description. There is no point in me explaining why companies are forced to close, but today we'll talk about how to do it in Russia and whether you can just abandon it empty forever. What happens if you don't liquidate your company? You may think that if your LLC doesn't operate, you can abandon it and the owner can be understood. The liquidation procedure is complicated and troublesome. And the legal entity will be ultimately closed itself by the Federal Tax Service, which may seem attractive. However, this decision may lead to some unpleasant consequences. Although a blank organization with no income or employees is not required to pay any taxes or contributions to different funds, it must from time to time report to regular authorities. For failure to submit such reports and returns, the LLC will be fined by the Federal Tax Service and the Social Fund. In addition, the company may be fined by Rosstat for failure to submit statistic reports. Note that business owners are also fined for this, and numerous fines may result in the foreign being deported from this country. So you want to shut your company down if it doesn't work anymore. What else? You might think that if your business has debts to contractors or clients and they try to collect money through court, then you don't have to pay them. The debt will hang over the company forever. Indeed, while an individual entrepreneur is liable for the debts with his or her personal property, an LLC is liable with its charter capital only. But its director and members can be held vicariously liable for its debts and liabilities by a judge. It's called literally subsidiary liability in Russia. That is, let's say a firm was declared bankrupt and bankruptcy proceedings were initiated against it. If the company's assets aren't enough to pay off creditors, then the remaining funds can be recovered from its management if it's proven that their actions led to debtors' insolvency. So if things are bad, simply pretending you are not involved won't work. Another point is, as I said, the tax service can but doesn't have to forcibly liquidate an abandoned firm if two conditions are met. No transactions on accounts, no reporting for the last 12 months. Today the tax service is actively cleaning up the registers of business entities. Often for this purpose, premises are inspected. Tax representatives come to the address to the LLC specified during registration to make sure that business activities are or aren't carried out there. If this is not confirmed, data on unreliability is entered into the state register. But when liquidating an organization with debts to the budget or organization that didn't submit reports, the majority participant and the director will be prohibited from registering another LLC and participating in its management for a few years, that it's disqualified. The tax service actively checks how real the business relationships are and requires that due diligence be observed. Therefore, companies have to find ways to find out everything about their potential partners. If one of the founders or directors turn out to have been disqualified sometime, even a long time ago, the chances of cooperation are practically zero. In addition, the opportunity to participate in competitions, tenders, etc. is blocked. So if you want to keep doing business in the future, be sure to close your inactive LLC down. Note that I'm talking about the Russian practice. In other countries, things may be different. How to liquidate a company? This process takes a lot of time. Although the steps don't have special names like dissolution, winding up, and termination in the English convention, it's still a multi-steps and complex process. Firstly, hold a meeting of the LLC members or prepare the sole founder's resolution if you started the organization alone. In the minutes of the meeting or the resolution, write that you decided to begin a voluntary liquidation of the LLC, approved the composition of the liquidation commission and its chairman, or appointed a sole liquidator. This function can be assumed by the director, accountant, sole founder, any of the LLC members, or any other third party natural or legal. The liquidator or liquidation commission will manage the company, including acting in courts in behalf of legal entity without a power of attorney. And 3. Approved the procedure and terms of liquidation. The maximum possible term is 1 year, and it's safer to indicate this. For example, if you indicate the liquidation period will be 3 months and the process drags on, it can only be extended by applying to the commercial court. This means paying a fee of 6,000 rubles and waiting for the court's decision. The second thing you should do is report liquidation to the tax authority within 3 days with a notification on the form number R15016. In 5 working days, the tax office will issue a sheet about the entry in the Unified State Register of Legal Entities that your company is in the process of liquidation. From this moment on, it's impossible to change the constituent documents. The third step is notifying creditors. Publish a notice of liquidation in the General State Registration Bulletin. This period can't be less than 2 months. During that time, everyone to whom your LLC owes the money can demand repayment of the debt. Within 3 working days from the date of the decision, enter information into the Unified Federal Register of Facts of Activities of Legal Entities, FedResource in Russia. Also, send a written notice of liquidation to counterparties to whom you have debts. Next, warn all employees in writing of the upcoming dismissal no later than 2 months in advance. Also, submit a written notice to the employment service no later than 2 months in advance, and if the dismissal is mass, 3 months in advance. When this period has passed, fire the employees and don't forget that you need to give them severance pay and compensation for unused vacation and maintain the average monthly salary for the period while the employees is looking for a new job, but no longer than 2 months. The fifth step. At least 2 months after the publication of the liquidation notice in the media, prepare an interim liquidation balance sheet. It can be done by an accountant. You will need to approve it at a meeting of the founders or by decision of the sole founder, and then submit it to the tax office, and it's also advisable to attach and its confirmation of publication in State Register Bulletin. The next step is paying off debts. Immediately after the approval of the liquidation balance, settle your debts in the following order. First of all, pay off the persons to whom your company is liable for causing moral damage or harm to life and health. Secondly, pay off the employees under the employment contracts for payment of wages and severance pay. A month after approval of the liquidation balance, pay off the debts of the third and fourth priority, namely pay all taxes and insurance premiums, fines and penalties, and lastly, the remaining debts. After this, you can draw up a final liquidation balance sheet, which is also approved by the members or one member. Within a month from this moment, you will need to submit some closing reports to the tax service and the social and pension funds. If your LLC has some property left, it's to be distributed among the participants. And finally, last step, filing for the company termination with the Federal Tax Service. The state fee for terminating a firm is just 500 rubles. As you noticed, there are plenty of nuances that a business owner should keep in mind to close their doors for good, and it's worth finding liquidation experts that will take care of the most of the things themselves. We have long experience in helping with the dissolution of the legal entities, so if necessary, don't hesitate to contact us. My name is Vasily Tarsenko, I'm a Russian attorney. Don't forget to subscribe to our Telegram channel also, please. Bye.